All right, this is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. Are you Brian Keith Taylor appearing there from the jail?
Yes, sir. Yes, Your Honor.
All right. Just a minute. We have to be quiet. This is case number 24 CR 137, State of Ohio versus Brian Keith Taylor. This is a pretrial being conducted by Zoom. The defendant's been indicted on 3 counts of aggravated trafficking and 3 counts of aggravated possession of methamphetamine. Mr. Taylor's attorney is Dennis Kirk, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. This is a final pretrial. I believe we have a trial date set for April the 7th. Now, I believe that discovery was filed. There's no, Mr. Kirk, did you file a compliance with discovery?
I did, Your Honor.
Okay. Well, we pulled these files last week, so we actually I see over here there's a red jacket. I see them. Yeah. Okay. And then it looks like the state filed an additional discovery this morning with a lab report on it. And you received that?
I did receive that. Yes, my client's not yet aware of it, but I will take that out to him.
All right. And I don't see any pretrial motions filed, or did you file any?
I did not. I did not see the warrant for any, so I did not file any.
All right. Now, what's the status of the case then in terms, I know we have a trial set on the April 7th, so that's actually inside the 14-day window, but I believe that this was the best we could do on the scheduling date. So what's the situation here with this case, counsel?
It's protected.
I have made my client aware of his plea offer. We did actually negotiate on that. I have made him aware of the 14-day rule. Also, the form to basically I forget what the technical term for it is, but basically the plea refusal form, gone over that with him as well. He does not wish to sign that form, but has not necessarily stated he wants a jury trial either. He did want me to go back to the state with some additional things, which I did, and they declined to change the offer. So at this point in time.
Welcome back to another jaw-dropping courtroom breakdown. Today, we're diving into Case 24, County Route 137, the State of Ohio versus Brian Keith Taylor. From the jump, tensions are high, multiple count of aggravated trafficking and possession, a pre-trial filled with confusion, and a defendant who clearly thinks he can outsmart the system. We got attorneys, prosecutors, and a judge who doesn't mince words. Trust me, he's about to put everything on the table. Stick around because you're going to witness sharp exchanges, shocking misunderstandings, and one of the clearest demonstrations of courtroom authority you've ever seen.
Are not representing yourself. The only way you can file a motion is if you represent yourself, in which case that would be a huge mistake, and you haven't asked for that, and there's be quiet, don't interrupt me when I'm speaking. I'll give you the chance to talk. You just be patient and listen, okay? One of your problems may be that you want to speak instead of listen. And that's a big mistake too. So, getting back to my point is that there's not what's called a hybrid representation system in Ohio, and that's a criminal case. The defendants can't file their own motions. Now, your attorney's indicated that he had reviewed these with you and didn't find anything that had any legal merit, arguable merit that he could file. And under the rules of law, attorneys aren't permitted to file frivolous motions just because their clients think they should. They're the attorneys. They're the ones that know the law. They're the ones that know the rules of professional conduct. They're the ones that are bound by it, not a defendant who wants to file any kind of number of motions based probably on what you've seen on TV or in the movies, which is, again, a real big mistake to believe that kind of crap. So that's where we're at. Now, going back to my question, are you rejecting the plea offer? Yes? Okay, then we will have a trial on April the 7th. All right, so does the state expect this to take more than 1 day?
No, the state expects this to be finished in 1 day.
Okay. And you agree with that, Mr. Kirk?
I would agree with that, and I would note just for the record, I've been given no names, addresses, phone numbers of any witnesses, so I don't think we'll have very many, if no witnesses at all.
Well, if there's going to be any witnesses, Mr. Taylor, you have to give those to your attorney so that he can file and respond. Those will due by today. So if you've got them, get it to him right away so he can give them to the state. I'll give you till tomorrow to do that. Now, Anything else that we need to discuss in this case?
Yeah, I'm gonna ask to have my attorney removed, and I got grounds here. I asked him to file a few motions which are legitimate. I mean, this ain't from TV, this is from going through the law book and studying day in and day out. Everything I got the case numbers, case laws, I got.
Motion, what kind of motions are you talking about, Mr. Taylor?
But one is a motion to suppress. One is, I got one here, it's a
Motion to suppress, but this is I believe this is a undercover buy situation, isn't it?
It is 3 buys.
Okay, so I don't know what kind of motion to suppress would be appropriate. What do you think could be suppressed?
It'd be.
Now, here's where things get wild. Mr. Taylor is struggling to make a clear decision. He's unsure about the plea offer, wants to file motions, but also doesn't fully grasp the legal process. The judge is calm, methodical, and unafraid to call out this lack of clarity. Watch as the courtroom tension rises. It's like trying to argue with someone using a rule book written in invisible ink. This moment perfectly shows the importance of having a competent attorney. Without one, you're navigating a storm with no map.
So you have an answer. What is it you would seek to suppress? Pardon me?
I don't know.
You don't know? Okay. Anything else you want to bring up?
I'd like to have my attorney move from the case and have another one, please.
Wait a minute, I'm having trouble understanding you. I can hear you.
I like to remove my attorney and get another one.
Okay, well, you have until April 7th to get yourself a new attorney. If you want to get a new attorney, you can do that. You'll have to hire them because you didn't hire Mr. Kirk. You didn't have the money to hire an attorney, so I appointed him for you. So, he's your attorney unless you get a new attorney. But if you do, they need to be ready to go to trial on April the 7th.
I can't get another court-appointed attorney. I can't afford an attorney.
No, you have a court-appointed attorney. I've given you a court-appointed attorney.
But he's not representing me.
Yeah, he is. He's representing you, and he's had conversations with you and discussions. You don't like what he's telling you. I get that. If I were in your position, unless they were telling me you're going to walk free and the state's going to give you a written apology and $1 million, I wouldn't be happy either. But, he's not going to do that. So, unless you can tell me why he has not, he shouldn't be your attorney, and you've given me no reason other than the fact that you don't like what he's saying, and he won't file motions that aren't proper, which is no attorney would file. So getting you a new attorney would not mean anything, because a new attorney wouldn't be able to file frivolous motions either. And if I gave you any attorney who knows what they're doing, they're not going to do anything different than Mr. Kirk is. Mr. Kirk's been doing this a long time. Now, anything else you want to bring up?
Yes, I have grounds, man.
I asked you what your grounds were, and you didn't tell me anything. You said you didn't know on suppression.
I'm trying to be respectful. Wait till you're done talking.
I'm sorry, what?
I'm trying to be respectful, man. Wait till you're done talking. You got only once for interrupting.
Okay. I asked you to answer my question, and you didn't when I asked you what your grounds were. Now, I'm not going to give you another attorney. If you want to get a new attorney, that's up to you. You feel free to do that. You'll have to hire that attorney. But I don't know who told you that you're entitled to get more than one attorney because the court has appointed you an attorney. Mr. Kirk is qualified and competent and experienced and knows way more than you'll ever know about the law. So just because you've been in court a few times doesn't mean you know anything about the law. Just because you got a book you can read doesn't mean you know anything about the law. I could read a book on brain surgery, but that wouldn't make me a brain surgeon.
Check out this exchange. Mr. Taylor wants to file his own motions, but under Ohio law, only his attorney can do that. No hybrid representation here. The judge patiently explains why this is a huge mistake, referencing rules, ethics, and common sense. You can almost see the frustration building. The defendant thinks knowledge from TV shows or books equals real legal power. Meanwhile, the attorney is caught in the middle, trying to balance professional obligations with a client who isn't engaging realistically. It's a masterclass in courtroom procedure versus ego-driven confusion.
Have a fair and just defense.
Oh, absolutely, and that's what you're going to get. We'll have a fair trial. We'll have a jury, and we'll have a trial.
I don't have all my discovery yet. I'm missing 12 things that I'm not discovered. I'm begging for.
Well, he's got the discovery. Let me explain here, Mr. Taylor. I met with your attorney and the prosecutors before this hearing, and he kind of outlined to me some of the things you're talking about. As I understand it, you have everything of any importance. I think he said you had mentioned that you didn't have a copy of the resume of the BCI analyst or something, which is minor. It doesn't mean much. He can get that to you. He will get that to you. But the other things that you want, I mean, my understanding, he's given you more than what most defendants get in these kind of cases, because usually there's a counsel-only discovery restriction. But since the identity of the CI is known, apparently they have let you watch the videos, right? You've watched the videos of the what they say are the buys, right? And then you've gotten copies of everything that he has, pretty much. Is that correct, Mr. Kirk?
That is correct, yes.
All right, so, and that's it. Discovery is what he's giving you what he has.
My discoveries don't even have counsel eyes only stamped on them.
It doesn't have to have a stamp on it. It's done by email.
And same time, I get a piece 1 week, I get a piece 2 weeks later, and I get a piece Monday.
All right. Well, good. It gives you something to do. So what? We still got 10 or 12 days to try. I mean, but again, you're not going to be the one that's going to be questioning the witnesses and presenting evidence and making arguments. That's what your attorney does. Pardon me?
Well, I'm afraid of.
I would be afraid too if I were on trial, but that's not why we're here. This is a final pretrial, and we're ready to go to trial. With the court, we're going to send out our jury notices today. State's ready to go, and you're going to be ready to go unless you get a new attorney. And again, you're not going to get it. I mean, maybe you can find somebody to be willing to take the case and go to trial on the 7th. But that's going to be on you. If you want another attorney, you can get one. But all this stuff you're telling me doesn't amount to a hill of beans, as my dad would say.
I represent myself.
Pardon me?
I represent myself.
Well, if you want to do that, how are you going to do that? What do you know about the law?
I don't know that much about the law.
And so you want to go to trial not knowing much about the law against a prosecutor that does know the law?
I think my percentages would be higher, yes.
Pardon me?
I think I would have, my percentages would be higher, yes.
Well, I can't understand what he's saying.
Yeah.
Truth bombs. He clearly lays out why Mr. Taylor's strategy is doomed. No frivolous motions. No magical legal loopholes. This is one of those moments where you realize courtroom experience isn't just about knowing the law. It's about controlling the narrative, managing a client, and keeping proceedings on track. And let's be honest, watching someone try to argue from a place of wishful thinking while the judge dismantles their logic is equal parts educational and dramatic gold.
Do you know what the separation of witnesses is?
That's one of my motions. Motion to seven.
Well, we don't get separation of witnesses, I ask you.
Yes, yes.
Okay. So what is it?
Ask 5.
Huh?
Motion to ask him to 5.
Okay, well, that is filed at the time of the trial. When we start the trial, that's an oral motion. What kind of a motion did you want him to file?
You have to give me time to get it.
No, you're the one that claims to know more than he does. You should have been prepared to tell me. If you've got all these arguments, don't tell me you got to sit there and try to figure this out, because we're not going to sit here all afternoon. You tell me what it is you wanted him to file. You just told me you wanted him to file something. Tell me what it is you wanted him to file. Don't tell me you got to go look for it.
I'm pretty organized here.
Well, why can't you answer the question then?
Because I can't tell you without.
Okay, well, look at it. You should be able to find it. I'll give you 15 seconds. Find it.
File a motion for the rest of my discovery.
There is no other discovery to file. Again, you cannot. Pardon me?
I got a list here.
What?
I think he's basing his list off of other
No,
people
I'm not.
because he thinks there's a set. No, sir. He thinks
Listen, be quiet. Let me hear what Mr. Kirk's saying. Go ahead.
He thinks there's a set number of discovery items. I've told him that is a myth. Some people may have 14. Some people may have 2. And I've explained that to him. However, he does not trust my advice on that. I do not believe he's missing anything other than there is a lab report that was just filed that I will be taking out to him. But he thinks there's some sort of mythical set number of items.
Okay.
Judge, I can probably shed some light on this as well.
Go ahead. No, would like to.
Some defendants believe that they should have copies of the buy money, for example. In this particular defendant's case, those are actually pictures that were on the digital evidence that he would not have access to out there because he's in jail.
Right, I understand.
There are several things that are digital evidence that he physically cannot have access to because he's in jail.
Okay. Well, your attorney has those, and he's shown them to you, as I understand it, right?
Yes, he showed me the digital stuff, but he has showed me, yes, right. But also, if they're going to have PCI experts on the stand, and we get a chance to cross-examine them, shouldn't I have their qualifications and all that for cross-examination? Also,
Cross-examination would be based upon their report.
Also, the submission report to the PCI lab, I don't have, and I don't have the physical.
Discovery confusion is a huge theme here. Mr. Taylor claims he hasn't received everything, but the judge and attorney clarify that he has virtually all critical evidence: videos, lab reports, and files. It's almost surreal. He has the materials, yet perceives himself as being left in the dark. This VO highlights a classic courtroom drama trope. A defendant convinced a conspiracy, while the reality is far simpler. The tension builds, and as a viewer, you can't help but cringe and wonder how someone could mismanage their defense this.
So,
Right? Correct? This right here is a signed paper that's in my particulars. That right there, if my daughter needed a permission slip to go to school, I could put this on it. That there says that goes to a bill of particulars. There's no date, no stamp, no nothing on my bill of particulars.
all right, well, it really doesn't matter. It's immaterial. You have copies of what is filed, and that's what's important.
I can answer this too.
All right, wait a minute.
I can answer this too. We don't file a bill of particulars in court because it names so much protected information.
Right.
We file a notice of filing. The
Right.
bill of particulars doesn't get stamped or anything like that. It's secret.
I understand, but it still has to have some type of something on it, because it can be reproduced. Everything I got can be.
Okay, well, again, you're operating from a complete ignorance of what's going on here. As she indicated, the bill of particulars does not have to be filed with a file stamp in the public file. And in fact, oftentimes it's not, because it names people that are to remain confidential. And in some cases, we've had a situation where the paper picks it up and prints it all before the trial, and then that person had all that information out there that could potentially prejudice the defendant. And so your complaint about it not being file stamped, it means nothing. That is a big fat zero that means nothing. You have a copy of it, and that's all you need.
Criminal Rule 16C says that it has to be prominently stamped, counsel eyes only. And everything they gave me.
Well, it's not stamped counsel eyes only. You've got everything in this case. Now, I'm not going to argue with you anymore. All right? The bottom line is, what you're saying is all without any legal merit whatsoever, because you've read a book and you think these things say this and that, and they don't. And you're not entitled to stuff that doesn't exist. You don't have to have stuff that doesn't have to be file stamped, and nothing that you've told me means has any legal significance at all. It seems to me that what you ought to be doing is focus on the allegations in this case and the evidence that you do have in this case, which is apparently some videos or audios
Now we hit the peak of courtroom drama. Mr. Taylor wants to fire his court-appointed attorney, Mr. Kirk. Claiming he's not representing him, the judge patiently explains the reality. The defendant can't just pick a new attorney without hiring one, and any competent lawyer would act exactly as Mr. Kirk is. This is a masterclass in judicial patience and authority, calmly dismantling unrealistic demands while still respecting the defendant's rights. For viewers, it's a mix of frustration, shock, and respect for a judge who doesn't let theatrics derail the proceedings.
This isn't about that. We're not going to argue about that. Whatever the evidence shows will be what is going to be introduced at trial if we're going to have a trial. And it sounds like that's what you want. So if you want to have a trial, that is completely fine. We're going to go ahead and send out a jury notice here this afternoon, and we'll summons in the jurors, and we will see you on April the 7th. Again, if you want to represent yourself, again, I would tell you that would be a big mistake. But if you want to file that motion, I will have a hearing on it and give you the opportunity. But I can tell you that you will absolutely have no chance in the world at a trial based upon your performance here today. Because just because you represent yourself doesn't mean you get to bring up everything that your attorney said you can't. Because if he says you can't do it, and he's right, which I'm guessing that he is, because he's been around the block a few times and tried cases in this court, then you're not going to be able to bring it up. And so when you're being upset with him not bringing up stuff you want him to, when he tells you you can't, it's not admissible, that's going to be the ruling of the court. And, most likely what will happen is, you're going to come in here thinking you can do this and that, and you can't, and I won't let you. You'll end up hardly having anything to say on your own behalf. You're not the first person I've dealt with that's represented themselves, or wants to represent themselves. And, if you want to do that, you can file a motion. There's a hearing I'll have to go through and ask you a whole bunch of questions that will point out, what a big mistake that is. You'll still have to have a legal advisor to stand by to answer questions for you at the trial. They won't be able to participate, and we won't start the trial you representing yourself and then coming to your senses and finally realizing you've made a big mistake.
Here, the judge delivers one of the clearest lessons of the day. Reading a law book doesn't make you a lawyer. He uses a simple analogy. Reading about brain surgery doesn't make you a surgeon. The courtroom tension is thick as Mr. Taylor realizes a gap between his perception and reality. For audiences, this is both educational and gripping, a reminder that confidence without knowledge is a recipe for disaster, especially in the courtroom.
I can tell right now that you're not going to be able to effectively represent yourself. But if you want to, once we go, just be quiet, I'm explaining. If you want to file that motion, that's one motion I'll permit you to file on your own. We'll have a hearing on that. And we'll go through all those requirements I'm going to have to do. I'm done with you now because I've got other cases I need to move on to. This is a pre-trial, not a trial. And I'll make that ruling. And so if you want to do that, I'll have a hearing on that, maybe Monday. And that'll give, and we'll see what's going to happen. Again, I'm telling you, do not try to represent yourself. And because, when you said your odds will be better, they'll be infinitesimally worse. They'll be so much, so bad that you can't even imagine it. And again, these cases, in cases like this where, you need to focus on what the evidence is as opposed to what you think the attorney is or isn't doing. That's the issue. Look at the evidence that you do have. What is the evidence against you that the state says they're going to present? And then make your decision based upon that. And as far as asking for stuff that's not out there, or stuff that you can't have in jail because it's digital, and your attorney has shown you those things, you have everything that the state has. There's nothing more they can give you. And so, you could file 135,000 motions asking for more discovery. If there's nothing more to give you, they're not going to be granted, So, what you're asking for is stuff that you apparently think you know about that you don't. And again, I don't know where you come up with these 14 items of discovery, but to the extent that you're getting advice from people that are in jail, think about, how smart they are if they're where you are.
You say I'm getting my different arrest. Every idea I'm getting is coming from the Criminal Handbook 2018, and everything.
Let's wrap this up. In today's case, Brian Keith Taylor is facing multiple serious charges, struggling to navigate the legal process, and under a judge who runs a tight, no-nonsense courtroom. the defendant's misunderstandings, demands for frivolous motions, and desire to fire his attorney highlight just how critical professional legal guidance is. The judge's clarity, patience, and firm stance provide a textbook example of how to maintain control in chaotic situations. If you found this case as shocking as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping breakdowns.